I'm going to go ahead and bring the attorneys in now.
All right, good afternoon, gentlemen.
Good afternoon, Your Honors.
Good afternoon, Your Honor.
Madam Clerk, would you call the next case, please?
50360, in re the estate of Richard Mueller, deceased, Jared Mueller versus Lance Leslie, Mark Leslie, and Brett Leslie, appellees.
All right, Mr. It's Piscopo, correct? I'm pronouncing that correct?
Yeah. Yes, Your Honor. Thank you.
Okay, are you ready to proceed?
I am, Your Honor.
Very well.
Thank you. May it please the court, counsel. This matter is a will challenge and involves a man who is undisputed, wanted the world and all for his 3 children. Yet, even as he's saying that, and originally, while they were all still under 20 years old, in 1997, he writes a will disinheriting them in favor of his second wife. This was extended in 2009 when he repeats he repeats the disinheritance, again in favor of his wife or his wife's own children if she happens to predecease him, which she eventually did. Richard Mueller's will and trust, created in 2009, left his 3 children nothing more than a small life insurance policy. His actual estate, which consisted of valuable farmland in Bureau County, would go entirely through his trust to his second wife, Carol Mueller, with whom he had no children of his own. And if Carol predeceased him, which she did, then it would pass to her own children and not Jared's own children. How can this have happened? The disinherited son, my client, Jared Mueller, filed a will and trust challenge in Bureau County, and he put together a compelling case that Carol Mueller was engaged in a decades-long campaign to separate Richard from his children, especially when it comes to their financial affairs and his financial affairs. But on summary judgment, the trial court first eviscerated the case by holding key evidence in support of an undue influence inadmissible, and then compounding the errors, the trial judge improperly weighed the evidence. Looking at that evidence in chronological order, Richard married Carol in 1989. Prior to then, Richard had his 3 children. The youngest was Jared, born in 1979 or 1980. And then they divorced in 1984 from Richard's first wife, Teresa. Before Carol entered the picture, but after the divorce, the children still had a good relationship with their father, and they visited him often, despite the divorce and despite the fact that Teresa moved with the children over to Kankakee County. Teresa related a story that the trial court improperly, we submit, struck. And that story was that when Jared was in 3rd grade, he talked to his dad and convinced him to stop smoking. The trial court struck this as hearsay. But the problem with that argument is that whether or not dad did stop smoking or did not stop smoking is not the issue. What matters is that Jared and his father still loved each other and they still worked together. They still did things together. So the trial court erred in striking that because the statements were not offered for the truth of the matter asserted. They were offered to show that there was a relationship between Jared and his father. Now, as the marriage between Richard and Carol gets started, it turns out that Carol announced her motive very early in the marriage. She said, and Lisa Emerson overheard her, that she wanted to be put on Richard's farm, and that was her goal. In fact, for her, it was a condition of the marriage. The trial court struck that as hearsay. But Rule 8033 clearly provides that the evidence of the declarant's state of mind, here it was Carol's, and that includes her intent and desires, is admissible. So then we get to the wedding between Richard and Carol in 1989, and the kids are excited. They're going to go to the wedding, and their dad's getting married again. They think he's going to be all happy, and this is going to be wonderful. And then the day before the wedding, Richard calls up Teresa and tells her that The kids aren't to be there. And Teresa could hear in the background Carol over the phone saying, those kids are not to be there. Creating an incredible situation where the groom's own children are disinvited from their wedding. And by this time, Jared is 8 or 9 years old, and the oldest, Melanie, is about 12 or 13. So these are not babies. These are regular children of Richard, the decedent. And yet Carol is announcing, it's Carol's call. Carol is announcing that those kids are not to be there, and Richard is just blindly obeying what Carol's telling her to do. That is the start of the long-term isolation between Richard and his children as done by Carol. After the marriage, visitation becomes more difficult. Teresa reported in her testimony that planned visitations were called off, often at the last minute. Eventually, Richard's mother, until she died in 1995, had to be a go-between. The respondents in their pleadings, they attempt to downplay this, but that's a question a fact for the jury to decide. It's not for the court to decide whether or not that is indicative of undue influence. That's a question of fact. And then we get to Jared's confirmation when he was about 13 years old. Teresa reported there, and again, this is something that the trial court struck. And again, it's not proper. It's not proper. It's not hearsay. And so it's not, the trial court striking it was not proper. Carol, once again, at the last minute, calls up Teresa and says, we're not coming to Jared's confirmation, an important event in a child's life, because we're going to have to bake cookies for our own church. That's not hearsay. It's offered to prove what Carol said to Teresa. The trial court struck it as hearsay. That was a clear error. It should have been allowed and considered. Now, as the respondents claim, well, it doesn't really matter. Richard made it to the confirmation. Well, the only reason he made it to the confirmation is because Teresa went out and on her own volition, bought her own cookies and brought them to the church. The church where Carol had claimed that they were going to have to bake cookies for, and so Richard was able to get there. What does that show? That shows, one, Carol was attempting, again, to isolate Richard from his son, although she failed this time. It also shows that Richard did want to see his son on a very important day of his life. This should not have been excluded as hearsay, and it's strong evidence that Carol's attempting an isolation campaign between Richard and his children. The jury, not the respondents in the trial court, should get to decide the meaning of Carol's attempts and what she was really trying to do here by having Richard bake cookies instead of attending his own son's confirmation. 1994, there was what everybody at below called the checkbook incident. And that was during a visitation. There was an argument between the children and Richard and Carol about money. The children ended up leaving the home, were found by a neighbor in the rain. And then they all confronted each other at the home of the friend who found them. And Carol was absolutely in a rage. She took charge of the conversation, announcing that Richard was not going to help Melanie with the college, not going to help Melanie with a car. And even in her anger, she lunged across a car hood. And that whole time, what's Richard doing? He's just standing there off to the side, saying nothing. Here, Carol is announcing in a fit of anger what kind of relationship, financial and otherwise, Richard's going to have with his children. And Richard doesn't do anything to answer to that. They also had the kids' bags ready to go. There was more time left on the visitation, but nope, it's going to be over at this time. And meanwhile, Richard's talking to his friends. He talks to Carl Grossman. He talks to Delbert Zimmerlein, that he wants the world for his kids, but he was sad and he couldn't see them often. And both to Carl and to Delbert, he expresses belief that Carol, as a strong-willed person, was calling out the visits. The trial court struck those too, but they fall within the state of mind exception under Rule 803.3. And I submit the cases of People versus Wills and Dorman versus Swaney, which we cited in our briefs. They stand for the proposition that a belief caused by the actions of others is admissible under the state of mind exception. In one case, an elderly lady said that she thought that a doctor was trying to swindle her and trying to get her out of her money in exchange for very little. And that was held admissible because it was her belief that she was being tricked by the doctor. And in the other one, there was a young girl who was excited because she was going to go get to see her mom in Missouri. Well, the only way she knows that is if her mom told her that she was going to see her mom in Missouri. So that's another belief and another state of mind that's caused by the statements and actions of somebody else. And in both cases, it was held admissible. And we submit that here too, Mr. Mueller, Richard, had this belief that that his ability to visit with his children was being controlled by Carol. That's admissible. The trial court also improperly struck the lay opinions of Mr. and Mrs. Grossman and Albert Zimmerlein that Carol dominated Richard. And they take a very restrictive view of Rule 701, but it's not nearly as restrictive as the respondents maintain. Opinions that can be rationally based on the perceptions of the witness. Mr. and Mrs. Grossman and Albert Zimmerlein both observed Richard for many, many years. They're their best friends. They're his best friends. They also observed him with Carol. He was in a good position to know, all three of those people were in a very good position to know how Richard believes and what he's thinking and what Carol is doing to them. So those opinions are valid and should have been admitted. In short, with regard to Carl and Delbert, Richard was telling them, and through them, he's now telling us what he really wanted for his children. He said, I want the world for my children. I can't see them because things go to yuck after Carol okays it. So he's telling us that he wants the world for his children, and he also is telling us that he's incapable of resisting Carol's demands. All that was admissible under Rules 803.3 and 701, and it presents a compelling case for undue influence to separate Richard from his children so that he would leave his estate to Carol and her children. But that's not all. There's also Melanie's wedding, when Melanie's now ex-husband said that Richard announced that he was giving Melanie $1,000 wedding present, and Carol became furious. And her ex-husband says her face said it all. I could tell she was angry because her face said it all. And the respondents argued and the trial court agreed that that's not a sufficient basis for an opinion. People do this all the time. And this longstanding case law supports it. People observe all the time other people looking angry, sad, happy. Somebody smiles, you know that they're at least content, if not overly happy. If they're crying, you know they're sad. If they have an angry look on their face, they know that they're angry. And according to Mr. Bloomquist, said her face said it all. That is a sufficient foundation. He had a chance to observe Carol and observe her demeanor, just like juries do when they observe the witness's demeanor, and they are entitled to draw conclusions as to that demeanor. And Mr. Bloomquist is doing the same thing when he says her face said it all. That should have been allowed, and that should have been allowed to show that Carol is not happy when Richard gives money to his children. And similar, when he also noted that Richard told him, Mr. Bloomquist noted Richard told him that Carol is angry about this. I have to do something about it. That goes to Richard's state of mind under Rule 803.3, that he feels his priorities are to soothe Carol's anger rather than interact with and support his children. 2007 accident. Clear evidence of isolation. The children were not even notified that Richard had his terrible accident with his tractor that ultimately resulted in amputation. They weren't even told. They couldn't visit him in the hospital because they weren't even told that. The logical person to tell them that is Carol, because she was there, or she's his wife, and she did not tell his own children that he was in a terrible accident. Now, Dr. Stephen Raffel looked at the medical records of Richard and the deposition testimony. He testified that we experts in the field of forensic psychiatry, we rely on those things. We rely on medical records. We also rely on a testimony from laypersons, because that tells us what the person's like and what he thinks and how he feels. And he concluded there's substantial evidence of isolation. And that isolation in turn can and often does lead to changes in the estate plan to take out the people who are isolated and substitute the person who's doing the isolating, and in this case, her heirs. The trial court struck almost all of his opinions, even though there was substantial evidence supporting it, much of which the trial court had also stricken. we believe that the trial court's stricken testimony, such as Carl Grossman and Delbert Zimmerlein, should have been allowed, and Dr. Raffel should have been allowed to rely on it as well. When we get to actual undue influence, we contend this is a secret influence cases under a state of Hoover. The respondents want to present the cases. This is all no big deal. This is really children's fault for not seeing their dad. That's a spin on the facts that the trial court is not allowed to draw on summary judgment. Based on the facts presented, both what the trial court allowed and what the trial court wrongly disallowed shows it's equally or more plausible that Carol drove them away from Richard's life and from his estate plan, completing her decades-old plan. As for presumed undue influence, there is a fiduciary relationship. The trial court was hung up on the idea that the will was not prepared by or procured by the beneficiary, but that ignores the isolation of Richard done by Carol over the years. And it also ignores the fact that he prepared both their estate, that Mr. English, the attorney, prepared both Richard's and Carol's estate plans in 2009 around the same time, sometimes met with them together. There's sufficient evidence preparing that.
Counsel?
Carol, yes.
Counsel, your time is up, but you'll have 5 more minutes,
Okay.
obviously, at the end. But just one quick thing you said. I thought
Sure.
my memory of the record was there's no evidence that she participated in any way with the creating of his will. I think Mr. English said, I don't think she was even there. If she was, I don't remember it, which obviously she wasn't wielding any influence if he can't even remember her being there. You just made some reference that there's evidence that she was somehow influential in the will, and I just don't remember that in the record.
Well, that's what the trial court was hung up on too. And I would agree that she did not sit there and help him draft the will, but there is evidence in the record that the two of them did visit Mr. English together on at least a couple of occasions. So it wasn't like Richard was solely involved there, and he sent the will to his house. What goes on behind closed doors, nobody knows. It's between Richard and Carol, but we believe that there's sufficient inferences there that would support a presumed undue influence.
Okay. All right. Thank you. Mr. O'Rourke,
Thank you, Your Honor.
you may proceed.
Thank you, Your Honor. Oh, excuse me. Thank you, Your Honor.
Oh, wait, I need to hold up. Counsel, I don't have any other questions, but Justice Anderson or Justice Bertani, do you have any questions for Mr. Scopo?
I don't.
Not at this time.
Okay. I'm sorry. Go ahead, Mr. O'Rourke.
Thank you, Your Honor. These Zoom hearings are a little difficult sometimes for that reason. I was trying not to talk over you, so I apologize.
Yeah. Well, that was my fault anyway. Go ahead.
Your Honor, in listening to counsel's argument, I have a flashback to a line that a student once used when I coached her in mock trial many years ago in high school. And she stood up unplanned and said, plaintiff's argument is heavy on emotion, but light on the law. And that's what we heard today. A lot of emotion, but none of the law. It is absolutely undisputed in this record that Jared Mueller had virtually no relationship with Richard Mueller for the last 20 years of Richard's life. Not surprisingly, Richard wrote him out of his estate plan. When asked in his deposition what evidence he was aware of that Carol, Richard's wife, in any way prevented Richard from exercising his own free will in connection with his estate plan, Jared answered, quote, I don't know what she did. That admission, along with the fact that Jared came forth with no evidence to meet the very high hurdle that the courts have required for an undue influence claim, is why summary judgment was proper and should be affirmed. Now, we're talking about a will and trust that were executed in 2009. At the time, Richard and Carol had been married for 20 years. Certainly not unexpected for an individual who'd been married for 20 years to leave his estate to his wife. And that's what Richard decided to do. He had no relationship with Jared, and by his own testimony, Jared attempted to have no relationship with Richard. For 15 years after Jared graduated high school, he never attempted to call Richard. He never drove over to see him. He merely bumped into him 2 times, once at his sister's wedding, which Richard attended, and once at a farm show, or excuse me, a farm auction that they both just happened to be at. That was it. The sole issue before the court is whether or not Jared came forward with sufficient evidence to survive summary judgment on this undue influence claim. not speculation, not conjecture, actual evidence. The trial court correctly held that he had not, and this court should affirm that decision. So when we look at the law, we know it's a very high standard. Both parties have cited the Baumgarten case. In fact, both parties largely cite the same cases. Undue influence is that which means it's excessive, improper, or illegal. The estate of Julian and the Baumgarten case both characterize it as an influence that prevents a testator from exercising his own free will in the disposition of his estate, or that deprives the testator of free agency and renders the will more that of another than his own. And importantly, there's a temporal aspect to it. The courts have said it must, quote, be directly connected with the execution of the instrument, operate at the time it was made, and be directed towards procuring the will. There is simply no evidence of that in this record. Now, on the topic of presumption, and that was something that the petitioner, Jared Mueller, relied upon heavily at the trial court and in this court's briefing, I think Your Honor hit it right on the head. What evidence was there that in any way Carol prepared or procured, that the will was prepared or procured by Carol? None. There's four elements to the presumption. The circuit court properly ruled that the fourth element, that a will was prepared or procured and executed in circumstances wherein such beneficiaries were instrumental or participated, ruled there was no evidence of that. And that's correct. When you look at the undisputed testimony from attorney Mike English, who prepared the 1989 documents and the 1997 documents, which, by the way, did the same thing, also disinherited Jared. Mr. English's testimony was, when Richard came in to do business, he came by himself. When Carol came in, often Richard accompanied her, but she was not present when he came in to talk about wills or trusts. He repeatedly confirmed that testimony in his deposition. Counsel's attempt to misdirect this court and believe that they came in together is directly contrary to Mr. English's testimony regarding the preparation of the wills and trusts. Did they at times come in when Carol was doing something together? Yes, but Mr. English made it abundantly clear that she was not present when Richard came in to talk about his wills or trusts. Mr. English also made it very clear that Mr. Richard Mueller was the same old Richard he'd always known in 2009 when he did this. He had no reason to believe anyone was influencing Richard, and that Richard clearly knew what he wanted to do.
And is I right? But Mr. English had been his lawyer for years, even before his marriage to Carol, correct?
That is correct. Yep, and Mr. English testified that he had known Richard for several years. It's Princeton. It's a small town. It's that sort of area where people know people. And Mr. English gave that testimony very clearly that Richard knew what he wanted to do. Jared came forward with no evidence to the contrary. Instead, he relies upon the Kaufman case to support a presumption, but in fact, the Kaufman case itself directly undercuts Jared's argument. In Kaufman, the court held that the wife had not procured the decedent's will, even though the wife in that case arranged for the attorney who drafted it to meet with her husband in the hospital room, was present in the room, and according to the appellate court, quote, inserted herself in the discussion. Well, if that's not sufficient in Kaufman, then there's absolutely nothing in this record that could ever lead to the conclusion that in some way Carol procured or participated in the drafting and execution of these documents. I think it's also important, and Your Honor, Justice Peterson, this goes to your question, the fact that he had known Richard and had been his attorney for several years was also something that the court in Kaufman found relevant, because in that case, the court found it was relevant that the attorney believed the husband was competent to execute a new will, and that while his, quote, deteriorating condition afforded the wife the opportunity to enlist the help of an unfamiliar, unwitting counsel to prepare a will that represented her wishes, not her husband's. She instead contacted an attorney who was familiar with her husband. In this case, Mr. Mueller contacted his own attorney who was familiar with him, not even Carol contacting anyone, Richard doing it himself. So the presumption argument the trial court properly held fails as a matter of law. So then we look at the actual influence argument. What evidence is there in the record that Carol acted excessively, improperly, or illegally and prevented Richard from exercising his own free will in 2009?
Can I back you up for 1 second? And this is going to go for both of you when Mr. Piscopo has his chance. Is you have the factual, the circumstantial argument on fiduciary that the relationship falls under the category of fiduciary relationship. I remember there was a power of attorney, but I don't believe the power of attorney that had been executed had any bearing on the will. In other words, power of attorney grants the authority to do certain things on behalf of, she would be able to do it on behalf of him, but that has no relevance to, I can't figure out why it would even be an issue. So are we talking about the fiduciary relationship just based on the circumstantial evidence? Is that how we're framing this for our appeal purposes?
Your Honor, they did raise the issue that there was some property power of attorney signed at one point in time. I think you're correct that there's no evidence that it was ever used. There's no evidence that it ever played any role in the procurement of this will and trust at issue. But I think what's also important to recognize is even if that power of attorney and the circuit court recognized this and didn't have to get to the ruling on it, because when you're talking about the presumption, there's all four elements that have to be proven. So even if there was a fiduciary relationship, that's only element number one. You still have to get in, according to the Baumgarten case and the DeHart case, you still have to prove the remaining three elements.
Sure.
The test.
Sure, I was just wondering if the power of attorney came into play at all. The power of attorney gives you certain authorities, but none of them would be involved in him going to get a will, or even both of them going to get even if she had gone with him, the power of attorney just wouldn't come into play whatsoever.
Correct. I believe that's absolutely true, Justice.
Okay. Go ahead. I'm sorry.
So with respect to the actual influence argument, then the question becomes, what evidence is there that at the time this 2009 will was executed and trust document, that there was any exertion of improper, illegal, or excessive influence? What evidence is there that Carol took away Richard's ability to exercise his own free will? Now, we've got a couple things to consider in that regard. One, Jared himself freely admitted in his deposition he was not aware of any evidence. We've cited that testimony in our briefing. Two, what they've done and what you've heard this morning is a masterful job at picking out a handful of isolated instances, oftentimes based on second and third hand information that they claim occurred over a 20 some year period. Instances that, as the trial court recognized, are not exactly uncommon in familial relationships, especially when families split, but none that got to the level where you could demonstrate anything was going on in 2009, that Carol was somehow controlling Richard and was forcing him to do something he didn't want to do. And in fact, the attorney who drafted it said just the opposite, that there was no indication that he was being influenced. He knew what he wanted to do, and he did it on his own. The argument.
Well, and let's back up. It's okay if he was influenced. It's okay if there was some influence. Undue has a legal meaning. It's as long as the influence was of the type, either it did or it didn't fall under the category that the law has given title undue. So even if he had been influenced by Carol to some extent, well, that's what marriages are. It's the undue is what we need to get to really talk about.
I agree 100%, Justice Peterson, and that is what the trial court focused on. The trial court concluded that there simply wasn't enough evidence to get to an undue influence to survive summary judgment on an undue influence claim. And at the trial court level, as here, the petitioner, Jared, relied largely upon the Hoover case. But in fact, as the court recognized, the trial court recognized, there are no facts anywhere near what Hoover had. And in this case, there is just simply there. I think the direct quote from the trial court judge is, "There's no there there," and picking out these isolated incidents doesn't rise to the level of some undue influence, or they continually want to characterize this as a secret influences case because there had been apparently some disputes over the years here and there. But again, they acknowledge that they don't know what was going on behind closed doors. And the reason is because there was nothing going on. There was no evidence of it. There's a lot of talk about the evidence that was excluded. I'm sure the court has read the briefs, and we've went through that in detail. We're short on time. I'm not going to address that here, but I would point out that in terms of what it takes to rise to the level of undue influence, the Baumgarten and the Cetera case are both very informative. In Baumgarten, the complaint alleged that the decedent was dependent on the wife to provide basic necessities. She constantly criticized him, scolded him, and caused him to change his will, but that was insufficient to survive even the liberal pleading standards of a motion to dismiss. The Cetera case is frankly much worse than any of the facts alleged in this case, and that didn't survive the motion to dismiss standard. In that case, the plaintiff alleged, or the petitioner alleged, that the beneficiary had threatened to disclose that the testator was a homosexual unless he changed the will to include him. The court said, no, that's not even sufficient, because the court found that, and this is the direct quote, even though decedent's deteriorating physical condition and a specific threat of exposure was alleged, petitioners have not alleged how that threat operated to overcome decedent's free will so that he was induced to execute his will in respondent's favor. Merely alleging that the decedent was dominated by the threat of exposure, enhanced by his deteriorating physical condition, was, quote, merely conclusional as to the operation of the alleged threat at the time the will was executed. So again, here, and that was at the motion to dismiss standard. Here now, Jared had years to develop evidence. And Jared went out knocking on doors. His prior attorney, and I don't remember if it was the immediately prior or 2 or 3 prior, he's had a number, went out and got these affidavits that were the subject of the motion to strike and put the conclusions in them that counsel has referenced. Aaron, I see my time has expired. I appreciate your Honor's attention and would respectfully request that the court affirm the summary judgment and the exclusion of the evidence.
Very well. Thank you, Mr. Scobel.
Thank you, Your Honors. Yes, counsel talks about how Jared had virtually no relationship with his father, but misses 2 things. First, he doesn't explain why. Why was there no relationship? And the answer, as shown by the evidence that we presented, is that Carol drove them away. Carol is the one who canceled visitations. Carol was the one who threw the checkbook and then lunged over the car. Carol was the one who got angry when it came to giving Melanie money for her wedding. It was Carol who drove them away. And the second thing he doesn't answer is, okay, let's give the benefit of the doubt to the movement, which you're not supposed to do in summary judgment anyway. But giving the benefit of the doubt to the movement, that doesn't explain why Richard also disinherited the 2 daughters. He lumps all 3 of them together. So all that is indicative that this was influence, and it was more than just ordinary marital influence. This was undue. This was
Counsel,
a person.
can I ask you about that? It seems to me that you're trying to present a lot of evidence, reinforcing the notion that this gentleman didn't have a good relationship with his children and that it was her fault. But how are you connecting that conduct to the procurement of his estate plan? Because they're not necessarily always related.
Yeah, and that's actually the reference in the Satara case that the council referred to. It does reflect his estate plan because in doing the isolation, you're making it when Carol was let's use the character. So when Carol was doing the isolation, she was alienating the children, Richard's children, from him, taking them out of his life and as little as possible, and eventually it turned into nothing at all. Despite Richard's willingness, he wanted to see them. He was happy to come to Melanie's wedding. He was happy to see them anytime. He told his friends, "I really wish I could see them more." He doesn't express anger as children for abandoning him. He just says, "I wish I could see them more." And
But we all
Carol
do
was
that. I mean, my counsel, we do that all the time. My son goes to school 90 minutes from me. Do I wish I could see him more? Sure, but that's just how life works.
this goes well.
If
This
he
goes well
wanted to
beyond.
see them, I don't know that. I'm just trying to connect the two dots. I mean, you have a bad relationship with his children, but you also have the creation of his estate plan, and it doesn't seem to me that, as far as I could tell, she wasn't all that involved directly in formulating his estate plan.
But you don't have to be the one who's actually writing up the document or calling the lawyer or anything in order to create that undue influence. And this is more than just my child's away at college. I can't wait till he comes home because I can see him. This guy almost never saw his children from 1994 all the way up until Carol died, and then he started seeing them again. But he never said a bad thing about them. He never said, "Oh, I can't stand these kids. I'm glad I don't see them."
Counsel, let me ask you this: even after she died, he had the capability to change his will, right?
Yes, Dr. Raffle speaks to that, and that's one of the opinions that the trial court did not strike. That after Carol's death, he was so depressed and sick and very sick himself that he really never thought about it and got the opportunity to change his estate plan. He never got. It was only a couple years, and he just never got around to it. So, but that doesn't. But if counsel wants, I mean, counsel made that argument below. But if he wants to do that, then that applies back then as well. And I think we've talked about that more in our briefs. It's the isolation that caused him to be separated from his children and not think of them when it came time to make his estate plan. And notably, Mr. English, on whom the respondents heavily rely, he acknowledged that, yeah, it's very unusual for a man to disinherit his children, who, by the way, are on an equal footing under the law with the spouse, because they have an equal right to take under if there's no estate, if there's no will. Mr. English acknowledged that raises a red flag, and yet he did nothing to ascertain if this was really his intent and why it was his intent. There's nothing in the deposition, there's nothing in his notes or anything that shows him why Richard wants to do the things he's doing. I mean, this is a man who says, "I want the world for my children," and yet he disinherits them. That doesn't make sense. And it's a reasonable inference that the reason for that is that Carol is isolating him, and Carol is keeping him away from them, and Carol is keeping him from supporting those children in any way, and ultimately prevailing on his estate plan.
But I mean, Justice Peterson and Justice Bertani are my colleagues and my friends. I want the world for them. That doesn't mean I'm going to give them everything I have when I die.
Yeah, but they're not your children.
I still want the world for them.
But when he says, "I want the world," people say that about their close family members. They say that about their children, and he's saying that about them, and he's not saying anything bad about them, and yet he's disinheriting them. And there's a reason for that, and we believe that the evidence is sufficient to take it to a jury and have them decide whether what was procured was Richard's will or Carol's. And for that, we respectfully ask the trial court to reverse the decision of the trial court.
Justice Bertani, do you have any questions?
Yeah, I'm trying to put my finger on it, but cannot, counsel. Was it recited in your brief that Richard, after Carol's death in 2015, either got a new insurance policy or added the children, his biological children, to a life insurance policy?
No, that's not in my brief.
Okay. I might have read it in a case then. I'm sorry. Apologize.
One last one, just a quick comment. Can I presume, obviously, your argument entailed what I presumed it would, all the circumstantial evidence of you're saying that first fiduciary relationship issue. And there's been no reference to this power of attorney. It just came up in one mind. I just want to make sure that everybody's on the same page. That's not you're not saying that she had a fiduciary relationship as it relates to the will is created from a power of attorney that's unrelated to the ability to execute a will.
I'm not saying that she used the power of attorney to create the will, but there was a power of attorney in existence at the time, which our Supreme Court has held creates a fiduciary duty.
Sure.
So
Okay.
I'm not arguing that she used it to create as well.
Okay. All right, thank you, gentlemen.
Thank you.
All right, we will
Thank you,
take
Your
this.
Honors.
Yeah, thank you both for your spirited arguments. They were helpful. We'll take this case under advisement and issue a decision in due course. Everyone have a good. You'll be escorted to the virtual waiting room and they'll let you out of here.